And Tammy, is Phil here, or
Phil is not going to be showing up.
Phil is not coming?
No.
Okay. Oh, we are on the air. Okay. Well, I'll take a deep breath. I will call the meeting of Wednesday, July 13th, 2022 to order. Would everyone please stand for the Pledge of Allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. I do want to introduce the board members tonight because we have a new member sitting for his first public hearing, and that is Mr. Beach. Thank you for volunteering to come on this board for us. And Mr. Cotton, Mr. Wood, Ms. Bovair, and my name is Mr. Ingalls. I'm the chair. We do have the town attorney, and I will follow up her name, but I'm going to give it a real good try. Ms. Rachin.
You got it. Perfect.
And she will be here helping me through any questions that might come up that I don't understand as being fairly new to the board. And we have the code officer who is basically speaking for the town on the letters that were written, Ms. McCabe. And we have a new, and we have Tammy, the planner, Tammy Bellman.
Yep.
Sorry, I never call her by her last name, so she is also here, and we have a new person taking notes for us tonight, sitting in the corner as well, Shannon, and I forget you, Rogers. Oh, I think I've got through that. Wow, this is good. We have no minutes for today. So, having said that, our only reason for being here tonight is an appeal. And because I haven't done many of these, I've tried to lay out some plan here as to exactly how this is going to go, and we'll do our best to kind of stick with what I'm anticipating is going to happen, or hoping that will happen. Now, do we have any members on Zoom tonight? Okay. Just when it's your opportunity to talk, if you just let someone know, raise your hand or something like that. In the past, it seems like you're familiar with how this is going to work. We've had people that are not on mute and tend to try to interrupt. If that is the case, we will just mute you from here so that we can conduct the meeting as we need. And like any time that we have a meeting, please conduct all the questions through the chair, and that way I can try to keep some kind of orderly fashion on the meeting. When we get to the discussion phase, like we've done in the past, if you raise your hand or something like that, or I know you want to speak, it's certainly going to be fine. So, this board obviously is here to try to address, come to some understanding of any concerns that someone might have with an action by the code office or the town that's they feel is in violation of the ordinance. That's why we're here tonight. So what we as a board need to do is hear proof. We aren't here to investigate anything. We just, when you're asked to come up and there's a concern, just try to address what your concern is so that we can understand, and we'll ask questions so that you can prove to us that there has been a violation of some sort in the town. Okay. So the next thing we're going to, once we open the hearing, we have to understand if what's been addressed by the applicant, Mr. Al-Darraji, is something that we can act on. So we will be probably asking the lawyer, Ms. Ranchin here, if it's something that she feels we have the authority to even hear. So that's going to be one of the pieces as we open the hearing, just so that that the board can understand where we're at and what our next step is.
And Mr. Chairman, if I might just
Yes.
round that out, you're exactly right. Before we get into the merits of any kind of appeal, there are three kind of threshold issues that we need to determine. One is standing, meaning that the applicant or appellant coming before you has essentially standing or the right to be here in the first place, right? The second piece, of course, is that you need to determine that this board has jurisdiction over it, and that's exactly what you were talking about. The reason being is that all municipal boards are essentially, and I'm quoting case law here, creatures of statute, which means they can only exercise the authority that they're specifically allowed to by state law or your own ordinance. So you've got to determine, hey, is this something over which we have jurisdiction? And the third thing is, which is the easy one, is the timeliness, right? So if it's not timely, if your ordinance doesn't allow you to hear it, or the applicant doesn't have standing, then you don't get into the merits. So those are the first three threshold issues that you get into, and then you go from there.
Right. Very good. Thank you. So, and if page 120 in our ordinance, if you, as we're starting to deliberate and understand whether we have standing, that's where our authority comes from. So I just I know you probably all are aware of that, but especially with Mr. Beach being new to the board, I tried to put down pages so that when I'm referring to something, we can all get to where I'm at when I'm trying to talk about anything. Does the board have any questions, not about the hearing, about what I've said and how I plan to proceed? If we don't, we'll open the hearing and then we'll start during the process. I just was trying to clarify and get a sense of where we're at, okay? Okay, so that was my introduction. I can flip this over.
Mr. Chairman,
Yes.
I have just one question. I assume that the appellant understands that they have the burden of proof.
Right, that's
And the burden of proof has to be backed up with evidence. And evidence can be anything from eyewitnesses, videos, letters, emails, but opinions are not evidence. Is that correct?
I would agree with you.
Okay.
Okay, having said that, I am going to open the hearing for Mr. Al Jazari. And it's on the application dated 6/2/22. Now before, typically, we'd ask Mr. Al Jazari as the applicant to be the first one to come up and speak, and you will be the first one. I just want to kind of break down, now that the hearing's in session, I've decided, and I think to hopefully less confusion, that we will take each individual concern, I believe there's two that you addressed, separately, so that we don't mix up anything that we're talking about. That way we can have our questions in whatever the first issue, and then we'll move on to the second issue. Is that going to be okay with everybody?
Good plan.
Okay. Having said that, I believe, my feeling is I want to start with item 11 on the application, because it seems like that one is going to be less involved than the first one. I'm not entirely sure, but I think it seems like it's going to be less confusing, so we can get, I don't mean to get it out of the way, but we get that one resolved, or get that one, some understanding on that one. And then we'll move to the second one about the subdivision. Okay, and the first one is the question of the, well, let me go to, it's the letter dated May 25th, 2022, about the subsurface wastewater disposal system. So that would be in your packet.
Mr. Chairman?
Yes.
If I might, I'm sorry to interrupt.
Am I,
No, I think just on the note that we were talking about before about those jurisdictional issues, before we get into the substance
Yes.
of the merits of this case, I think you might want to hit the timeliness, your jurisdiction, not personally, but of the board, to hear it, and also standing. Because if any of those things are not found to be met, then you don't get into the merits.
that's,
So-
I was gonna actually do that separately, so I'm glad you brought that up. So on item 11, that's the first thing that I wanted to discuss. And that is the question of standing, like Ms. Rasheen said. I know that, and I'm gonna let Ms. Rasheen speak to, I had some initial concerns about the Supreme Court case, or the Superior Court, I'm sorry, case, and I believe, I'll let her speak to it, but she doesn't feel like that has any bearing on the decision that we're gonna make on this. Am I speaking correctly on that?
I may be missing a beat. When you're speaking about a Superior Court case, I'm not sure. It was referenced in the materials.
Yeah, it was just
I'm
referenced
sorry.
in there, and the
Yes.
question is, do we want to be acting on something if it's in front of Superior Court?
Yeah, I think that what this board is limited to is the appeal. You have two, as I understand it, as I was reading through, again, the applicant will tell you what he thinks his
Exactly.
appeal is about, but I see two letters, one May 3rd,
Right.
one May 25th, and the essence is, your job is to decide whether or not the code enforcement officer, or LPI, as she was serving in either of those capacities, was right or wrong.
Right.
Not what's happening. I think the issues here are, what does the ordinance say? And, or what does the subdivision law say? And did the code officer or LPI
Right.
get it right? Now, I have absolutely no earthly idea what the Superior Court case is about.
But you don't, sorry.
So what I'm saying is, if the applicant thinks that it somehow bears on the legality, or whether or not the determination under the ordinances was correct, then he should have some leeway to just mention what that is. But clearly, we're not going down into the merits of a lawsuit that has
Right.
nothing to do with the scope of what you're looking at.
And I guess that's what the concern was. Did it have any scope in what we're looking at?
Yeah.
Okay.
Yeah.
So, having.
But I will say, I will be skeptical that it would, and I'll tell you why. Because if we are here in this room as the town of Berwick to determine whether a town official made an appropriate determination, right? If the town was somehow involved in this lawsuit, we'd probably know
Would
about
know.
that.
That makes sense. Thank you. Okay. Having said that, there's a specific reference to a particular item in the ordinance on this one, and it refers to where am I here? It's on page 62, FC. So where there's been a specific item in the ordinance that's being requested for us to review, it seems like we would have standing on this issue. Mr. Al Jazari mentioned that his concern was FC on page 62, so I believe we do have standing to hear what his concerns are. So, based on that, I believe that this board should hear Mr. Al Jazari's concerns about that particular part. So, right now, can we just focus on that, and then we'll, once we get this one resolved, or get an understanding, then we'll move to the second one.
You may need a better understanding of where I'm coming from, though, if you hear.
Could you, sorry, Mr. Algie, could you stand up?
feel like you might have a better understanding as to where I'm going with that argument when you hear the rest of the argument. But I can try to approach it separately that way if you wish.
I think the only thing we're going to be able to act on is what you've referred to. So I guess that's what I need you to explain to me, what your concerns are with the letter dated May 25th, 2022. What do you think that the town has done incorrectly in that regard?
Well, you look at you have that in front of you, 711 FC states that septic systems serving on a structure on one lot are not allowed to be located on abutting or neighboring lots. And so that's exactly the condition that my neighbor had with me. He had his septic system crossing my boundary lines and onto my lot. So I requested from Mrs. McCabe to provide a violation letter to give them, stating that they are in violation of 711 FC, and to have them move their septic system. At which point, Mrs. McCabe didn't even respond to that request. And I continued to push it and continued to ask for it. And it didn't seem like she really was forthright and wanted to provide that. She did mention that it was not in her wheelhouse or not part of her job to take care of that, and that's a civil matter because the deed had wording that provided that septic system to be there. And so I went on to say, well, easement or no easement, the provision does not allow that, and that is not the intent. There is no exception in this provision that says if you have an easement that you can continue to put the septic system here. And so she then, after I explained that to her, a week later, I get a letter stating that not only does that not matter, but they are not in violation because the easement in her mind is all that mattered, and that they should be able to keep their septic system there. So she took what I said when I said there is no exception, and then she added the exception as though that is within her wheelhouse to do so, and sent a letter to me stating just that. You have that in front of you, the letter, everyone?
Yep, 25th letter.
Okay. So she goes out of her way to say that it's illegal whether the easement was there or not. So to me, that is not in part of what she should be doing. She should have stuck to the code and provided me that violation letter. But as you probably read my complaint, this goes way beyond that. This has to do with her being a neighbor
Okay.
and favoritism. So
Now, it's my understanding that the septic system now is located on the appropriate property. Is that true?
that's correct. So since she didn't provide me the letter, I sent my own letter to their lawyers and to them saying that you guys are in violation of 711 FC. And so they took that to heart, and they went ahead and moved their septic system entirely onto their land.
So at this point in time, there's no violation. Is that true?
At this point in time, there is no violation.
Okay.
But the point was being is that I have an ongoing civil matter in the Superior Court with these people, and my job was to prove to them that they were in the wrong. And this letter would have gone a long ways to show the judge that, listen, these people are in the wrong. Here's a violation from the town. But I wouldn't get it. But now what I got is a letter that favors her neighbor, that says it is allowed, so that they can take that to the court and say, oh, look, the town said it was okay. There's an exception here.
I understand. Unfortunately, I don't want to use that choice of word, probably a bad choice. We can only act on what is there. And right now, if that septic system has been moved, there's no violation in the ordinance, so I think our authority at that point in time is done.
I don't agree with that, because that letter should have been provided to me. I should have that in my
But
folder.
I don't have the only thing I have the authority to do is to look at the ordinance and make sure the ordinance is followed. And at this point in time, you've told me that there is no violation of the ordinance now. the septic system is on the appropriate property. So I can't make any finding here because I don't have the authority to make that finding. The board has no, there's no violation now of the ordinance, so there's nothing that we can do for a finding.
Well, there's a letter that
Just
states-
one second.
Sorry.
Am I missing something?
It's a little difficult because the facts are unclear here, okay? There is, as you probably well know, this concept of mootness, right? In order for there to be, for a board, or I'm just likening it to a court, so I'll analogize to, you're the court, essentially. That in order for you to weigh on something, there still has to be a live issue in controversy, and if not, then it becomes moot. And I think that's exactly what you're arguing. Now, I think an important question to ask is, we have that letter dated, I think this was the May 25th letter?
Correct.
I hear Mr. Al-Darraji, am I pronouncing your
That's
name
correct.
wrong? Right, saying that at the time, perhaps, that letter was written, I think that's something you might want to ask, is that at the time, and maybe the code enforcement officer,
Right.
in conjunction with Mr. Al-Darraji, can clarify that. At the time it was written, was that septic system already moved onto the property? If that's the case, in my view, that's determinative. What happened in the past is irrelevant. To me, what's critical is what was the state of affairs at the moment that was written.
The letter, the time of the letter. Okay. I can, yes.
The letter that I just received was way beyond, well, the septic system was moved quite some time ago. This letter, I just received this letter that says that that was not a violation. So what you're saying is that this letter shouldn't exist either, because it was a moot point. It's been moved, so why does this letter exist that favors her family friend?
Well, we'll let the code officer come up and address that. I can't speak for the code officer, so why don't we let Ms. McCabe come up and address that?
Mr. Chairman, you may just ask if that piece of his, I know you said you wanted to take them in 2 bite-sized chunks.
Right.
And I know that your rules specify that you want the applicant to go on interrupted. So you might ask him if that's it with respect, or if those are his full submissions with respect to the septic issue before the code officer comes on.
Well, my intent was to just get clarification on that, and then at that point in time, I'll excuse Ms. McCabe,
Sure.
and he can come back up if he feels like. So, could you address the question that I think is before the board now, of the timing of this letter?
Sure. Do you want me to just address that question, or do you want me to just, how
Well,
would you like me to proceed?
I guess, I think it's on the record now that at the time of this letter, that there was no violation. Is that true now?
So that is true now.
I mean,
Yes.
at the time of the letter, it was true. Is that
That's
right?
true.
Okay.
I would like, but can I say a couple things just for
Sure.
clarifications for the board on behalf of the town? Can
Well,
I just have some time?
At this point in time, I'm going to bring, I know I'm kind of convoluted here, but I'm going to bring Mr. Al Jazari back up to make sure that, and then if you feel that there needs to be more said from the town, I'll give you that opportunity. Okay, Mr. Al Jazari? So I guess it's been confirmed, you confirmed it, but the code officers confirmed that at this point in time, there was no violation with the letter. Is that right? And there was no violation at the time of this letter.
Right, this letter was written when the septic system has already been moved.
Right.
And it was because I continued to ask for the letter in emails, saying, where is the letter? How come I never received the letter? Why didn't I get the letter? And when she said that was not in her job description to take care of that, I was quite surprised, because based on what I've read, that is exactly what she's supposed to do, is to see if there's any violations and make sure they get corrected. But regardless, she finally sent the letter, but it was in the opposite of what I was asking for the letter. She made it with an exception. She included the exception in the letter that she made up that has nothing to do with 711 FC. She just threw it in there to make it work. That's what I'm trying to get at. So that in itself is not...
I understand, and I don't mean to interrupt, but I can't control her letter. I mean, she felt it was necessary to put that in there, then she can speak to that. But again, as long as the violation, there was no violation at the time of this letter, I think for us as a board, our standing is done. And Ms. Ration said it a lot better than I did, but basically, we don't, there's no violation for us to act on here. I know that the letter may not have said exactly what you wanted it to say, but the code officer is gonna put down on the letter, she can speak to it, what she feels is necessary, not what you might necessarily want in the letter. It's gonna be her letter with her name and her signature on it. She's gonna put in there what she feels is necessary. So I can't speak to her on that. So unless there's something overwhelming more to this part, do you have anything further to say on that?
Well, I want this letter to be revoked because this letter is untrue and all it does is favor the civil suit for her friend to win a case against me. So this letter should be revoked.
Okay.
It's not lawful to say an exemption exists when there is not one to exist.
Okay, well, so let's let Ms. McCabe come up and speak to that. You have the floor.
Thank you. So, Mr. Chair, members of the board, let's just go back in time a little bit to see what happened here, so you guys can understand a little bit further. The lot splits that are in question tonight that we're not speaking about right now, Mr. Al-Darraji owned the property and he performed the lot split with the septic on another parcel of land. Just to be clear.
So it was originally on one piece, and when there was a lot split, it ended up on another piece. Am I understanding that correctly?
Yes, that's
Okay.
our understanding as the town.
Okay.
So, Mr. Al-Darraji came to the code enforcement office during the time where COVID was happening. We were working half remote, half on site. James was there. James talked to him. I spoke to him. We never disregarded anything he said. So he brought it to our attention that there was a clause in the deed that they had to move their septic system. He wanted us to write a violation letter. The town of Berwick, we try to work with people before writing violation letters. We've spoken about this before. Mr. Keys and his wife are, they're not abutting neighbors of mine. They are not, I don't know them. I know them because they used to walk in our neighborhood. They don't even live in our neighborhood anymore. When I approached Mr. Key about moving his septic tank, his problem wasn't not wanting to do so. His problem was he wasn't sure where to start. To get a septic design, you have to call an engineer. And sometimes you can leave messages for months for them, and they don't always call you right back. And anybody who's built a new house recently or during COVID or even tries to do anything right now would know that it's really hard to get a call back. I'm not sure that's the case. I know that the Keys told us that they were trying to find an engineer to come up with a, subsurface wastewater disposal plan. Finally did that. As soon as they got that plan, they acted on it immediately. And they moved that septic onto their own property.
Okay.
So, and to speak to the letter and why this letter was written, it was a recommendation of our town manager to give Mr. Al-Darraji, who wouldn't accept that it was closed and it was finalized, as an answer. We just wanted to give him the opportunity to appeal it if he needed to. So that's why the letter was written. It was actually written on Mr. Al-Darraji's behalf. Just so that he had something to come here with today, so that he could have his case known and heard.
Thank you.
Okay?
We can talk about the exception that she just decided to add.
Can you step up, Mr. Jazari?
She was supposed to come up and talk about the exception that she decided to add to the 711 FC. The exception being that if you have an
The easement to
easement,
the
you
deed.
can have a septic system on the person's land. Where did that come from?
Did you want to speak to that? quickly?
Yes, so if you look on the first paragraph of that letter, it had an easement access, the SWWD from map, U1, whatever. That easement, it says it right there. We included it because it's actually referenced in the Registry of Deeds.
In Registry of Deeds.
We didn't write an exception there. We put it in there for the board.
Right.
So you could
because
access it.
That's
Yep.
that's what you found during your.
Well, because that's part of the information, right? So
Right.
that's what he's appealing. So it's right there, so that if you guys wanted to go on the Registry of Deeds and pull that up, you knew exactly where to find
I'd
it.
like to see
Right.
it.
Yeah, I will just say this is just being procedural. It may have been referenced, but if it's not in the record, that's important. This board doesn't do its own research to find documents. It must be presented by either of the parties.
Right.
So.
Thank you. Do you have any questions for me, or?
I think I'm all set at this
Thank you.
point in time. So I guess I'm going to defer to Ms. Rachin quickly here. I believe we don't have any standing at this point in time.
Do you mean-
It's been resolved. I mean, the issue that before us that was referenced is that the question about it being on someone else's property now is on the appropriate property. So I guess I'm not sure what we need to do
Sure.
from this point.
Okay, so again, just to broaden the lens and trying to make it as simple as possible, not that any of this is simple.
Right.
But the job of the Board of Appeals is to determine whether or not the applicant or appellant, same thing, has carried his or her burden of proof, you mentioned burden of proof, to establish that the code enforcement officer, or LPI in this case, erred in her decision, okay? So that's the question. Did she make a mistake, essentially?
Okay.
And here, you're doing this, and I don't want to throw around legal terms, but we're a Board of Appeals here, but there are two standards of review. Sometimes boards of appeals take an appellate review. You're just kind of looking at the record before you. You have broader powers here. You do what's called a de novo review, and that's just what it sounds like, from scratch. You get to look at all of the evidence, hear from the parties, and make a decision. Did the code officer get it right? Okay? And so that's really the question. Was she wrong or was she right? You look at the letter, you see the basis for that decision, and you determine whether she got it right or wrong. And that's entirely within your purview. I think you'd ask me the question about, okay, what's the relevant time period here? I think I answered that question. And then you make that decision. I think the question is less, well, hey, there's no more violation. I think the question is, was there a violation at the time the letter was written? And that, to me, is the question before you.
Okay.
Mr. Chair,
Yes.
I think we need to see this deed. It's a very relevant, this easement. We need to see this piece of paperwork and see if it was in fact, at the time when they split it. If it was in fact there, then there's not a problem there.
One thing I will say, and I think that maybe the code officer at LPI can address this issue, right? We absolutely have these provisions that are put forward, and I think relevant here is 711F, right? But these are, I don't have the ordinance. Do you have the full ordinance, Tammy? Mm-hmm. My sense is that these are performance standards or general standards that must be met when there is an application before the board that they're considering, right? Hold on one sec. These are in the general performance standards, general requirements, okay? So this is what the code officer, planning board is going to be looking at when they're approving something, okay? Who knows when this was approved? I don't know when this was approved. There's nothing before this board or anything that I've heard from the code officer or the applicant about, what we're talking about here. So yes, maybe when this lot was conveyed, a building permit was issued, this should have been all of these criteria. It's not just, it's parking, it's signs, it's buffer areas, it's explosive materials, all of these things should have been considered. But just because there is a provision in an ordinance that says X, Y, or Z has to happen, if that building permit or that lot was developed 20 years ago, who knows if these were even in effect at that time, right? So you might not have to go into that and look at the easement. You may just decide, look, A, there was a requirement. We don't even know if that a requirement applied at the time this deed was split. We have no idea, right? But even if it was, the problem at the time that letter was written was resolved. And I think you can make that decision based on that. I mean, if you're inclined to get additional evidence, by all means, you can certainly ask for that, I think. But I also would recommend that you have the parties, they each make their case. They have the burden, or I should say Mr. Al-Darraji, as the applicant, has the burden. If that evidence is not before you, then it's their burden to submit that evidence to support their own case.
Okay.
And the same applies, I mean, not that the code officer has any burden of proof, it's the applicant's. But if, you know, again, she has every right to put in whatever documents she wants in support. But, you know, as one of your board members said, the burden is clearly on the applicant to establish their case, which requires, of course, the submission of evidence to do so.
Did you have anything else that's relevant to this?
Well, I mean, we just got done saying that, you know, it's not really the duty to decipher the laws and have you do search of and decipher the law. That's not really what you're here to do. And that's exactly what she's doing when she adds that easement exception into 711, because that was never there. That's something she just decided to add. That's not up to her to do that. That's my evidence, that she added something that's not in there on her own accord to help someone out. That's the evidence I have for you. The fact of the matter is, if you continue to read the deed where that says they have an easement, if you continue, which is the part that she happened to leave out, it states that the grantor has mutual say in where the new septic system will be replaced. But that wasn't in there. So see how convenient that you're getting half the easement information? So that's kind of why that's not in your department, because you only hear half the truth. The other half is still in the deed. You can read that as well. And there's an addendum to the deed that was also written. That was not discussed in her letter. So only the part that helps her neighbor is the part that was put in here. All the other relevant information that says that that easement was extinguished and was no longer there, she left that out.
We don't have the deed.
Right, but you have the fact that she wrote an exception that doesn't belong in a code. That's enough to say, why is that exception put in there? Why did you just happen to put this one exception in? Why didn't she put the exception that benefited me? Why didn't she write, oh, well, the grantor has mutual say. It says you're an easement. The grantor has mutual say in where the septic system replacement goes. Why was that not in there then?
Did you want to speak to that?
Mr. Chair, we simply put what deed, book, and page it was because you guys get these documents ahead of time. You guys were welcome to look up that deed ahead of time. We didn't write any information that was in that deed, just simply where to find it.
Thank you.
Mr. Chairman, in an effort to just kind of address some of the issues and concerns Mr. Al-Darraji had raised, you know, as I said, I think the important piece here is to determine whether or not it was an error at the time the letter was met. You look to the ordinance provisions, even assuming they apply here. So let's assume they do. The ordinance says, and I'm citing from 7.11FA, which requires each proposed lot must be served by a septic system located within its boundaries. So the question is, at the time that letter was written, assuming this ordinance even applies, was there a lot serving, or was the septic system that served the lot on that lot within its own boundaries?
So,
Excuse me, Chairman?
yes,
Their old septic system is still on my land. They have not removed it. They refuse to move it. They think that was their land, but it's not. They're trying to steal the land. They won't be able to, but they won't remove that septic system. It's on my land still. So this is still relevant. Even though they put the new one on their land, a new one was put on their house to serve their house. They left the old one sitting in my front yard.
I expect you're going to have to go to court to get that resolved. I mean, we
Well, that's,
don't,
well, I'm sorry, but that is still showing you that it's abutting, it's still existing. So we thought it was no longer existing, but I just want to back up and say, yes, this issue is still existing because they never removed the septic system off my front yard. So it is still existing. That septic system is still there.
I think if the board is okay with what we've listened to, we'll move on to the second, or should we act on this one first? I mean, we can do it either way.
Yeah,
I guess.
I think either way is fine procedurally, but frankly, why not do it while it's fresh in your mind?
That's what I was
And-
thinking.
And the board, you know, your fellow board members may have some questions of their own, and
Right,
if
and then
not,
we-
then you move on to sort of deliberate on this particular piece, and then you can make whatever motions you think appropriate with respect to this portion
Okay.
of the appeal.
I think that sounds, I hesitate to close the hearing, because typically we,
Yeah,
We
I don't
we-
think you need to do that. I would
you know, like I
just,
say, we've done that and then
Yeah.
basically close the
they're
public
not two
comment.
separate appeals, they're just two
Right.
prongs.
So-
Yeah.
Under the advice of our lawyer, I think this is the time we should discuss any questions that we'll move into the discussion phase of this. We've closed the public comment on this particular piece of this item one. Are there any questions, concerns? What's your choosing here, I guess, is opening up the discussion piece. Do you have any questions or any concerns? We can talk amongst ourselves. This is the time that we're able to deliberate, to kind of come to some understanding of what we're prepared to do. Are you comfortable with what, I guess, where we're at is, at the time of the letter, I think we've heard that the septic system, which is what was referenced here in the ordinance, was in fact on the property, the person's property where it was supposed to be.
Nope.
I don't know what else that we have the authority to do on this one. I know there's some concern about the old septic system, but I don't think that's in our preview to resolve, but what do you think?
I see septic system serving a structure on another lot are not allowed. I realize it's still there, but it's no longer serving them. If you were to look in the words on a trait C here. So serving would be in use.
Right.
It's now in the wording there, it's disconnected now. It's no longer serving. It's
Right.
existing, but it's not serving.
It's also abutting and crossing my line.
We're closed the public comment at this point in time.
So
How you doing? You comfortable with what has been discussed here?
yeah.
What do you think, Pat, Ernie? You have,
I feel like that the letter on this date, the septic had already been moved. So I feel that issue is no longer relevant, and the part that Mr. Al Jazari is still dealing with civilly in civil court, we don't have anything to do with. So we only have the letter to work with, and if everyone is in agreement, which seems to be, the code enforcement officer and Mr. Al-Darraji both agree that at this point in time, on May 25th, 2022, the septic system had been moved, then that's the fact.
yes,
Yeah, it's all about the timing of the letter. And I have not heard any evidence that would substantiate that there was a violation, or that there was a mistake at the time of the letter. So I would be in agreement that we don't have that authority to invent things.
And I feel that the letter is, and I
Mine's
feel
probably-
that the letter then was done, the letter is correct. I don't know if correct is the right term, but the letter is not a mistake. We're trying to determine if that piece of her decision is a mistake or not. I would say this letter is not a mistake.
So, do we want to make a motion to, I guess I'm going to,
Absolutely, I'm happy to help formulate, and I can sort of lob something out there, and instead of repeating it, you can say so moved, and somebody can second it, and
All right.
you can be off to the races, if you agree. So I think what you could say is, whoever makes the motion could say, I move to deny the appeal relating to the May 25th, 2012, excuse me, I am really dating myself, 2022 letter from the CEO LPI indicating that there was no violation. I think that's what you say. Does that make sense? That you're basically, you're denying the appeal on the basis that the May 25th, 2022 letter was in error. And basically, you're in doing so, what the practical effect is to say that code enforcement officer did not err, and therefore you're denying the appeal on that basis.
want to move that? Good.
So moved.
So moved, Ernie. There's a motion on the table. Is there a second?
I second.
Pat seconds the motion. Any further discussion? All those in favor? Do we want a roll call, or can we just?
If you're all present, I see somebody's out there, but I'm not sure if they're a board member. If
Not
they're
a board member.
Then if everybody's physically present, the FOA law on remote participation does not require a roll call.
If I could say something, I want to validate the fact that the appellant, excuse me, the appellant has the right to appeal, and it's an important part of town government. Unfortunately, given the evidence that we have, we cannot support that appeal. But I want people to know that the right of appeal is always there, and that it's for me a lesson that when we start thinking in terms of going before boards of appeals or in court cases that are adjudicated in the courts of our country, that you have clear evidence and that it's substantiated by more than just one piece of evidence. So I just want to make that statement for the record.
Okay. All those in favor of the motion that's on the table? Raise your hands, please. All five have agreed with the motion. We have a second item on the agenda, or a second part of this appeal, and that is involved in a subdivision question. The letter on this part of the hearing is dated May 3rd of 2022, where the code officer has said that there needs to be subdivision review of some the permits that were brought to her. So this one, I really kind of was a difficult part for me trying to understand whether we should even hear this, and I'm very thankful that the lawyer is here tonight to speak to this. Before I ask her to speak, my concern is I couldn't really find anything in the ordinance that specifically talked about subdivision. There's a piece in the ordinance that talks about the definition of subdivision, and then you move on to go see subdivision regulations, but I didn't think we had any standing as far as what subdivision regulations were. So, but I will let Ms. Rasheen talk to her, because she convinced me, well, she's going to try to she convinced me she needs to convince the board that we have standing to actually hear anything to do with subdivision. So I'm going to let you speak.
Absolutely, I'm happy to. And I, to be very clear, this is absolutely your decision. And I'm really not trying to convince you in any way, positive or negative, but I just wanted to give you kind of my thoughts on it and why I would recommend hearing it, okay? So again, back to that notion that you only have that authority that you're specifically given. Absolutely right. You look at, I mean, what is at issue here is the subdivision statute, and arguably the subdivision, even though it's not referenced in Ms. McCabe's letter, the subdivision regulations the town has deal with the very same issues about what's a subdivision, what's required, the review process, and it's taken pretty much verbatim from the subdivision statute, which she quotes here. In your powers and duties under the land use ordinance, because the subdivision regs, totally separate ordinance. Oftentimes in some towns, the subdivision regs are part of the land use ordinance. Here, separate and distinct in a totally different box. You look at those, there's absolutely no discussion about appeal, except to go to Superior Court because it's an appeal, arguably, of a planning board decision, which makes perfect sense. This board should not have to reinvent the wheel for, you know, those planning boards. Sometimes they go for, a year reviewing something. So of course you don't want to have that. That goes right to court. So what do you have the authority over? You have the authority over three things. Interpretations of the ordinance, which is the land use ordinance. This is not the land use ordinance that we're talking about. You have authority over variances. This is clearly not a variance. You have and I'm going to read it out, forgive me for being kind of pedantic here, but administrative review, right? You have the authority to hear and decide appeals where it is alleged that there is a land use violation, let's put a pin in that, or an error in any order, requirement, decision, or determination by the code officer in the enforcement of this ordinance, okay? Well, we know it's not that. It's not the enforcement of this ordinance. It's the enforcement of subdivision statute, or arguably the subdivision regs. But it says, the first part of that sentence, which is before the or, says to hear and decide appeals where it is alleged that there is a land use violation. Now, subdivision law, in my view, is very much a regulation of land use, right? And so if there is a violation of subdivision law, one would argue, or one could say, that it is a land use violation. And so while it's not pretty and it's not wrapped up in a neat little bow, and reasonable minds could differ, I would say that we are here. What you may not want to have to, as much as we enjoy each other's company, you might not want to have a remand if the court decides that you do in fact have jurisdiction because it was a alleged violation of an alleged land use violation. We could be back here again having this same deja vu all over again. So I think there is enough here that authorizes this board to exert its authority. I could be wrong. If somebody appeals this decision, the court could say, hey, nope, there's no jurisdiction here. But what could happen is if you decide that you don't and somebody wants to appeal that decision, you go up to the court. If we're wrong and they say, land use violation, subdivision reg, that's a land use violation, we're back here. They remand it back. So my view is there's enough here that says you have jurisdiction. And in order to hear this, that may mean that you don't have to hear it again if we're wrong. that makes any sense.
So, again, the question, do we have standing? Is the board comfortable with the explanation of why we should hear this part of the appeal? I'm kind of looking for us, there's no sense of moving on if the majority of this board thinks that we shouldn't be listening to this and we want to remand it basically to Superior Court, because that would, I believe, be his next step if we don't hear this. Are we okay?
Yes.
Okay? Fantastic. So, having said that, Mr. Al Jazari, the board is going to hear your concerns about the subdivision letter. Let me just make sure I don't have anything I wanted to say before that, before I have you come up. It looks like, so we've referenced the letter. Everyone has a copy of the subdivision, so that before we get started here, we know.
Do you have a copy of it? No.
Subdivision ordinance?
Yes, do you have a copy of the subdivision ordinance?
Land use.
You just have the land use?
Right. Because as she said.
It's not something that we
It could
typically
be-
see.
Could be, and it couldn't be, doesn't have to be.
If need be, I'm more than happy to read out the relevant definitions, if that would be helpful.
And I have also I believe, a second copy here, but let's, I'll let Ms. Rachel speak to what it is, what we're gonna be talking about here, and I have a copy that I can pass around too as well. Would you go ahead and?
Yeah, sure. I mean, so if we look at the letter, and again, I hesitate to go too far down the road because you'll have the parties who are
Right,
making their
sure.
submissions. But bottom line is, this is the question of whether or not the property is or should have been subject to subdivision review by the planning board. And under the state statute, it does require that any, well, let me just tell you what a subdivision is under the state law and your own subdivision regs. If it is, then state law is clear that you must actually go to the planning board to get approval for that subdivision.
Have that, yes.
So subdivision is defined as a division of and it's complicated. A division of a tract or parcel of land.
Sorry.
Oh, good, you have another copy. A division of a tract or parcel of land, which itself is a defined term that we should look at the definition of that. But a division of a tract or parcel of land into 3 or more lots within any 5-year period that begins on or after 1971. So this is the tricky part. This definition applies whether the division is accomplished by sale, lease, development, or otherwise, okay? So that otherwise is really not super helpful, but it, in my view, demonstrates an intent to basically say, if you're gonna divide your lot, whether you sell it, convey it, or I don't know what otherwise means, but it's pretty broad that the intention here is that that will constitute a subdivision, okay? The term subdivision also includes, and this is structure or structures, so I'm not gonna talk about that because here we're really talking about a division of a lot, not a building, okay? And then it gives some guidance, what it means, like what does divide mean? What is this division? And it says, in determining whether a tract or parcel of land, again, there's that term again, a tract or parcel is basically, well, let me just read it to you, I won't paraphrase. A tract or parcel means all contiguous land in the same ownership, except land that is located on opposite sides of a public or private road. So if it's in contiguous ownership, it's a tract or parcel. That's the basic gist, okay? So let's go back to, in determining whether a tract or parcel is divided into 3 or more lots, the first dividing of the parcel is considered to create the first 2 lots. And the next dividing of either of those first 2 lots is considered the third lot, okay? So, then there are a bunch of exceptions to that. And I won't go through those. But, so I think your analysis here into determining whether, again, your job is to determine whether or not the code enforcement officer erred in her determination in this letter. That's your job. You look at the definition of subdivision. You determine whether the property at issue was or was not a subdivision. And if you determine it was, then the law says any subdivision must get planning board review and approval before lots can be conveyed. And if you find A, that this falls within a subdivision, and B, therefore, that it required planning board approval and did not obtain it, then I think the natural conclusion is to uphold the code enforcement officer's letter, meaning she did not err, and therefore you would deny the appeal. If, on the other hand, you believe she has erred in her determination, then you grant the appeal. And that's your analysis. And I know it's somewhat complicated, and I'm here to answer questions as you go along, but I think the next step, of course, is to let the applicant make his case, and then you hear from the code officer.
Can I have one clarification, Mr. Chairman?
What's that?
Can I have one clarification? You mentioned across the road, does that mean that means contiguous?
The tractor parcel?
You had one lot, and you had two lots on one side of the road, but one of the third lot is on the other side of the road. Does that still mean contiguous?
It does, except lands located on opposite sides of a public or private road are considered each to be a separate tract or parcel unless, and this is critical, the road was established by the owner of the land on both sides. Okay, so that's a critical piece of information.
Because it was originally contiguous, and therefore they put a road in.
Exactly, exactly. So that in and of itself would not mean they're separate tracts.
Right.
Good question.
Thank you.
Yes?
Okay. So everyone's got a somewhat of an idea. I think that it's could probably get a little confusing on where we're headed with this. So given that, Mr. Al Jazari, would you like to come up and present your case?
Well, I'm looking at the letter I received from the town, and the first sentence is that Rosario and Allison Pellegrino divided their land and created 3 lots. Now, I'm not sure why that's on this. I bought, my mother and myself bought these lots in good faith. I mean, we were told that these were lots that we could purchase, and we purchased them, so I'm not sure how I'm responsible for something that they may have done. But I will say that it was divided up by civil consultants, and from what I can understand, it's been legal. You received the deeds from that back in 2013, and we haven't heard nothing in regards to anything being done incorrectly at this time. This is the first time we've heard anything that's been done incorrectly since 2013.
Did you want me to speak on that, or do you just want to continue
No, I'm going to
on?
just continue if it's all
Okay.
right. So as I said, we had purchased the 3 lots from the Pellegrinos, and my mother purchased one of the lots. I purchased another lot, and then her and I purchased one together. That was the 3 lots that we purchased. And at no time did her or myself ever divide any of those lots more than 2 times. She said it takes 3 times to make it a subdivision. We never went beyond 2. And as a matter of fact, if it's okay, can I approach and provide you a flow chart that would make this a lot easier to explain if you follow along?
You have a flow chart?
Yep.
Thank you.
Because there's a lot of deed numbers, a lot of book page numbers.
Thank you, sir.
Oh, sorry, it's 2 there, so.
If you guys as the butters want to see what he's looking at, they're right here.
So, and that flow chart goes with this right here.
Thank you.
Oh, good, it's big enough have to see.
And Mr. Chairman, may I just ask for the record that that document that's being presented is identified? I'm just not sure what it is.
It's the same document that's in the letter.
So the plan?
Yes.
Plan, okay.
Well, the same one that was in his application, it's just a lot bigger. And did you get a copy of the flow chart?
I have it, yeah.
Okay.
Thank you.
So,
So do you have another copy of that bigger plan?
um,
If you don't, it's.
no, I'm sorry,
Okay,
it's
no
not.
problem.
So the flow charts, you know, as you can see, they start at the top. That's where Rosario Pellegrino, God rest his soul, sold us those lots in 2007. Number one was Joyce Al-Darraji, number two was Joyce and Adnan Al-Darraji, and number three is Adnan Al-Darraji. So that was on January 8th, 2007. And those are all book and page numbers and all registered in New York County Registry of Deeds. 1, 2, 3 there. And what I did there is I put 3 different boxes so you can just follow along and it shows quite clearly that we never divided any lot more than 2 times. And we only done it once. I've owned this lot for 15 years and we've only split it once. So if you follow the arrows down, under number 1, we sold 1 lot to a Tom Michelson, and that's his book and page number. And the other lot went to my father-in-law, the back lot to that lot. That back lot went to my father-in-law, and he held on to that. And the number 2, Joyce and Adnan Al-Darraji, we decided to keep that. I put a garage on that. That's probably going to be where I put my home. So that was just showing that it's just the 2 lots under the same name. Nothing fancy there. Number 3 is under my name, and you can see I sold one of the lot, the front of the lot to Roman Pasquarella, and I kept the back lot for myself just to have. And now you can see those deeds are all been registered, and they're all in York County Registry of Deeds. So there is no issue that can be looked up. That's all verifiable. So at that time, as Jen had said, I had gone in to discuss getting a building permit and to start working the land. The economy was coming back, and I wanted to get a building permit to start building, and went to go talk to them, and we discussed it, and we talked about property lines and frontages and where the driveways would go and all to that effect. And it came to our knowledge that the tax maps were never adjusted when those deeds and lots were developed in 2013. I'm sorry, they were sold on 2012, Tom Michelson, and 2012 to Roman Pasquarella. So those deeds, we found out, were never taken by the town, and none of the tax adjustments were made to those lots. So, in a sense, Tom Michelson, or the current owner, has been paying for Bruce's lot, and Roman Pasquarella, or the current owner, has been paying since 2012 my back lot taxes. So I agreed at the time. I said to James, he said, well, you know, you're going to have some back taxes owed. And I said, that's no problem. I'd be happy to, whatever that adjustment is, to refund Tom Michelson or Roman Pasquarella or the current owner if they deserve a refund. No problem. And his comment was, to make that happen, I had to register the deeds so that the taxes could be done and the permitting process could begin. So then at 2021, I went ahead and registered the deeds upon his request, just to find out, not too long after, that same action of registering those deeds is now, he's saying, is my violation, and that I will have to start all over again, because now those lots are all 1 lot now, is what I'm being told. So that is pretty interesting just all by itself. If you think about it and you look back at this, you would say that had the town just adjusted the tax map back in 2012, that for Roman Pasquarella and Adnan Al-Darraji, and then for Tom Michelson and Bruce Brady in 2012, if that was done, then there would be no issue here. There would be no back taxes owed, there would be no need to think I would need to register and record all the other 4 deeds that I had. Now, mind you, I had those deeds for 8 years. And I said to James, I said, I don't think we need to really record this until I convey or sell one of these lots. And then, but he insisted that that's the way to get the permits, and who am I to argue with, the planning board manager at the time, so of course I registered the deeds. But what's absurd here is that by registering these deeds upon request, I am being told I'm in violation. And that these lots are all contiguous now, and I'm back to 1 lot. And I have to start all over again. So that's what I'm being told by code and by James. Now, so of course I asked to talk with them and have sit-downs. I mean, there's all kinds of emails where I requested more information, and I've received nothing relevant to why they feel all of a sudden I have to start all over again. But you can see clearly in the flow chart that none of the lots were ever divided more than twice. And I gave you the drawing so you could see that all these deeds are accounted for right in the drawing. They're all, so if you look at number 1, Joyce Al-Darraji, she is the lot A. So that's lot A right there, and Bruce, I'm sorry, it turned out to be Bruce Brady who ended up owning that, and that's lot A, and his name is right on there, and it shows the deed, it shows the book and page number as him owning that back lot, and it's a completely different deed and page number than the other 2. And then you'll notice on number 2, that was for Joyce and Adnan, that was lot B and C, and I said again, my garage is on B, and C is right next to it. We haven't really decided what we're going to do with that, so we didn't convey that to anybody or sell that to anybody. But the page and book number are right there, you can see those. And then on number 3 is lot D, and you can see lot D where the name is there and the book and page number, all different from what is seen on the other ones, and Norman Pasquarella right in front of it. So there's no surprises here. Everything has been registered properly, recorded properly. So I'm confused, to say the least. Well, I was confused until I learned what really was going on. And then you know that story. There's a family friend, and she's trying to
We'll keep,
help.
we're just gonna stick with the facts here.
Yep, that is a fact.
So, in your flow chart, you're saying that all 6 of those deeds, when you broke each of those 3 lots up, those all had deeds that were recorded?
Yeah, everything's been recorded. Everything you see listed on that flow
When-
chart is verifiable.
When were they recorded?
It says right there, 2012.
Okay, so
So you must have received a copy, or Berwick, I know, receives a copy of every deed from the York County Register deed once they've been recorded. And so someone must have dropped the ball and not done the tax adjustments that they needed to do and notify the people of the new lot lines.
But you're only showing 2 that were recorded in 2012, is that true?
Yeah, well, 2012 is for Roman, yes, and Tom, because the other lots deeds are still, as you can see, they never changed. They went from the top box of unknown, say, look at number 3. So that's unknown Al-Darraji. At that book and page number, carried on down to the next box.
Oh, I'm
It's
following
still
what
the
you're saying
same
then.
deed, never changed. And that goes for all of the other boxes as well. 1 deed carried down and 1 deed was developed for the new lot that was sold.
Until we revise the deed when the lots split, the same deed moved us down.
Well,
Right.
it'd have to be revised
Then
because,
the deed has to be changed with the parameters and
Right.
and everything, so.
right.
So, I'm sorry, what was the question?
So if you split a lot, you're gonna have to change the deed for 6, we'll take item 1 here. So you got Joyce, and it gets split to Tom and Bruce. You got 1 deed that's registered,
New deed.
and then the map, the size of 61-1 has to be smaller now, right? If you've cut a piece out of it.
That's correct.
So that deed, shouldn't that have been registered?
It has been registered, and it's under book 16412 and page 184. And that date, I'm sorry, I must have omitted that date and when that happened. I apologize, but that, obviously, you can refer to the York Registry County Deeds to see that that is there. I just forgot to put the date on that.
So do you have the date? I mean, did
No.
they get recorded at the same time?
I don't have the date on me.
It would have had to be, the action affected
I
both
imagine
pieces
it's
at the same time.
Yeah, I imagine it's the same time.
Well, it's, yeah, it's, I mean, it's in the same. So that one split. How did you come up with these numbers? Or you just, I mean, what I'm having a difficult time following is, I can go back, the tax map should show and reflect when you change, when a deed is sold, when a piece of property is sold or there's a deed registered, the tax map should change so that we can
right.
see that those are two lots split off.
I agree, and that's why I was told that each deed that's registered at the York County Registry Deed does get sent to the town for that reason.
So, all of these, every one of those happened in 2012, is what you're saying. All
That's-
those splits.
That's what I'm thinking. I apologize, I missed that one date, but yes, that's what would make sense.
Well,
Well,
there's
it's 1, 2, 3, 4. There's four of them that
four
don't have a
dates
date.
that aren't there. And that's the four that carry down to the next.
And that's the four that carry down,
Right, so,
but they never needed to be carried down. They could have been left just the way they were. They never needed to be carried down. Because the tax adjustment could have taken place right within that one box frame right there. We never needed these other deeds to be registered to take care of that tax situation. I could have held on to them.
wait a minute here. So you registered them twice?
No.
I mean, you're showing that you registered those four deeds in 2021, not in 2012, right?
So this is when James said, hey, sorry, it was not known yet. It was kind of not known by the town. He did it, York County Registry of Deeds. And then when he came to inquire about doing some building, and said, oh, these aren't on our books. So he said, register them. So he went up and registered them again. And that's
Can you
what's screwing
register
him
them
now.
twice?
So,
I think you can register things twice, it happens all the time, but I'm not sure if that's what was
No.
happening.
What happened, why they had to be registered a second time, it didn't have to be, first of all, we didn't have to register them a second time, but why there are different deeds, sir, is because there's so many right-of-ways and so many different things that had to be signed over, so a small triangle may have been on one person that had to be moved to another, so that whole, the reason why those are all different deed numbers, because all the square footage and all the perimeters of the lots all changed, the frontage, the side lines, everything changed at that point, so of course, they would need a new deed for that. And that's why they're under new numbers. But again, none of that had to happen. I've had these deeds for 8 years. I've had these since 2012.
Do you have a copy of those deeds for us to see, so that
Well,
we
they're
can?
in the York County Registry of Deeds. They're all
Well,
registered
that doesn't
now.
help us tonight. I mean, we need to see the deeds and some dates.
I could have printed you 100 deeds today, but I was gonna save a tree. These are all online. I didn't think you'd need to see every one of these deeds.
Well, we're talking about when parcels got broken up, and are we following the 5-year time frame for breaking them up? So
Well, these-
clearly, we need to see when these deeds, when this happened, and at what time these, what date these deeds, at the time that these deeds came into effect.
Yeah, well, I wrote them all down. I missed, like I said, I apologize for the one that was missed.
Well, you've missed 4, and it's the same 4 that come all the way down, and I think that's that's where we're at the question right now, is we've got 4 parcels here
Yeah.
that
Well, if you want, I can take your laptop and go on yorkregistry.com right now and find those dates for you in about 10 minutes if you want. And we'll take a recess. I can come back with the dates if that makes you happy.
Mr. Chairman,
Yes.
can I ask you a quick question?
Yes, Aaron.
Could you, in just very simply, what is it that you're appealing?
They won't
Because
give me
you
any...
have the right to appeal, but I need to know what exactly, in clear language, what you're appealing.
I'm appealing the fact that Jim Delismo and Mrs. McNabb here want me to go back and start all over again through the planning board to get a building permit. So I'm trying to get a building permit, and I'm appealing the fact that they're denying me a building permit for a lot that I divided legally.
Which lot are you trying to get a building permit for?
I was trying to start with Lot A.
Doesn't Bruce Brady own that now?
He did, but I've since purchased it from him, and now it's deeded under my wife and my name.
And you're saying that, that the letter that's being referenced in this appeal, which is dated May 3rd, is the letter that you're saying is, well, I'll let you, what problem do you have with this letter?
Well, it starts off again, it's saying that the Pellegrinos did something incorrectly, which I don't feel that should be my responsibility, if that is in case true. I'm not even saying that is true, but that's what they're saying. And then the other part of the letter that I disagree with is, right at the bottom paragraph, it says, for purposes of subdivision analysis, lots A through D are considered the same tract of parcel of land. And that's only because I recorded the deeds upon the request of James Bellissimo. So now, because I did that, they're holding that against me and saying, that's one lot now, you gotta start over.
Okay, so that's where the error, you're appealing, you're saying that that's an error.
That was an error that can simply be corrected. I mean, if we thought it needed to be there for a tax adjustment, then fine, but if it's not needed, that's okay, but don't hold it against me. Don't hold it against me because I did it. Because I only did it upon your request to help with the tax adjustment and to help with getting permits.
Sorry.
Yes, Pat.
I'm trying to understand
Sure.
this diagram.
Yes.
So if we take number 1,
Yes.
and we start with Joyce. Joyce has taken her parcel and divided it once to Tom, and then divided it again to Bruce.
No, at the time of that, she got rid of both of them. She got rid of one to
She only
Tom,
had one.
and got rid of
She
one.
only had number 1,
And now she got 2.
and so she divided it one time to Tom and divided another time to Bruce.
It's divided once and sold to 2 people.
That's correct.
All right, so
It turned into 2.
that was not a subdivision right there then.
No.
Oh.
The second parcel,
Mm-hmm.
is it true that the second parcel was divided into 2 pieces?
To Lot B and C, but we didn't convey it to anyone new. It was stayed within our family. And then the third one, again, is only into 2, and one I kept with me, and one I sold to Roman Pasquarello.
What about, do you have more things to say?
Do I have what?
Do you have more to say? Are you finished here?
Well, let's see. Well, if there's no other questions, I believe, this seems to be a simple misunderstanding, if nothing more. And I would be happy to adjust the deeds and convey them to which a way that satisfies the town. If they need me to change a name on something, I'll change a name. This is all within family, so it's easily done. This is not like this is written in stone. So I just wanted to let you know that. And again, just to verify, each owner has made only one division since that time in 15 years of ownership. It's not like we were just dividing, going crazy, dividing lands everywhere. So I guess that is it for me then.
So this last set that James told him to do, it was simply administrative. Nothing got split at that time.
It doesn't appear so.
It was just administrative. I feel like we have to look further into, you can only do, you're limited to split land every 5 years, to have 3 every 5 years, If there was no split, it was an administrative change, nothing changed with land. Land wasn't split at this time.
Well, let's maybe
Yeah.
let the code officer speak,
Mhm.
and maybe she can clarify something, and then at that point in time, we can
Okay.
start to,
Mr. Chair, members of the board. I'm going to first read the memo that I have written for you today, and then I'm going to clarify some information for you, and then I'll be done. On January 5th, 2007, the Pellegrinos divided their land and created 3 lots in a 5-year period from the same tract or parcel of land. 1, Pellegrinos to Joyce Al-Darraji. 2, Pellegrinos to Adnan and Joyce Al-Darraji. Number 3, Pellegrinos to Adnan Al-Darraji.
those 3 right there.
The above explained lot split required subdivision review then, by the Town of Berwick Planning Board, which was never applied for. Mr. Al-Darraji has outlined for us today that in the following years, the 3 lots were then divided or conveyed on several other occasions, resulting in 4 contiguous lots owned by Adnan and Tina Al-Darraji, better described to you as lots A, B, C, and D in front of you, and 2 other lots owned by other individuals at this time. None of the described lots have ever had planning board approval, or it was never applied for planning board review at all. My recommendation for Adnan Al-Darraji, Joyce Al-Darraji, and Tina Al-Darraji is just to simply apply for subdivision review for these lot splits from the Town of Berwick Planning Board, as lots A through D are considered the same tract or parcel of land under 30 MRS 4404, Section 6. If you have any questions for me, I'd be happy to answer them after I explain 2 more things. On January 12th, there was a memo written from the town manager. Do you guys have that in front of you, or do you need it?
We don't
What
have
year?
it.
Don't have it.
What year?
2022?
Okay, now.
No.
Okay.
You don't have it.
We just have this. Oh, okay. This is from the time manager.
This is from James Lisma, town manager. Thanks. This memo states, the subject parcels portions of U1 6D1-2 are located on Merriam Street Extension, and Merriam Street, and illustrated on the enclosed unrecorded sketch plan provided by civil consultants titled Land of Adnan Al-Darraji, Joyce Al-Darraji, and Douglas Bruce Brady. Shall I continue, or do you need to? Okay. Adnan and Joyce Al-Darraji conveyed 4 lots to Adnan and Tina Al-Darraji, illustrated on the plan without planning board subdivision approval. The conveyances were recorded at the York County Registry of Deeds and are referenced below. The conveyed lots include an easement over a right-of-way, illustrated on the plan in front of you. Based on the information, it is believed that the property constitutes a subdivision per 30A MRS 4401, Section 4, and would need to be reviewed and approved by the planning board. It is believed that the grantor had not reviewed the subdivision regulations with the town prior to transferring the property. As such, the assessing department believes the new lots. Actually, I'm sorry. Take that off the record. This is not from James Blismo. This is from our town assessing department, Karen Fortier. I apologize for that. I misread it. Anyways, it's, as such, the assessing department believes the new lots have been created illegally and therefore cannot be accessed to their highest and best use, which, without town approval. So it goes down to just show you exactly what's been conveyed and when it was conveyed. Remaining acreage of lots are listed on the bottom. Now, let me tell you what's been going on. So, Mr. Al-Darraji came into the Code and Planning office again at around the same time as we spoke about before, or he stated he did. He is correct on that. He came in and he wanted to convey these parcels. He wanted to talk to us about it. The problem with it is we tried to give him the benefit of the doubt. We tried to kind of like look in the history of the lots. That's what James and I did. James was the town planner, not the town manager at the time. I want to make that clear. We did a bunch of research in the town of Berwick office to try to figure out who owned what. It was always confusing. Who owned what, when the lots got split, what happened, was there ever planning board approval, whatnot. Mr. Al-Darraji told us, please contact civil consultants. They'll be able to tell you what's going on. I personally did that. I called civil consultants. I asked for Mr. Harmon on the phone. They asked me what I was calling in reference to, and I told them, and he had refused to get on the phone with me. And I was like, okay, so he wouldn't take my call. About probably 20 minutes later, I got a call in the code enforcement office here in Berwick, and it was Mr. Harmon himself calling me. He said, Jen, I'm really sorry. What do you need? So I just explained it to him. I got halfway through my first sentence, said Mr. Al-Darraji's name, and he said he's no longer a client of us. We cannot speak on behalf of this application or this plan, and hung up the phone. So I don't know why. I didn't ask why. I don't have the details of that. James and I were then left to figure this out for ourselves, to figure out what he actually owned, what he was trying to convey, and what he needed to do. James did not advise him to, and I was sitting right there, James did not advise him to go to the Registry of Deeds and register 4 lots at a time. He didn't do that. James advised him to register 1 at a time as he was building his, subdivision that you have in front of you here, okay? Because it was the legal way to do it. So that part of this is wrong. That's really all I have for this. If you have questions, I'd be happy to answer them. I'm not sure exactly what more pieces you want me to share.
Do you know, I guess the part that still confuses me is how we recorded these pieces of property twice? Or are they in his flow chart, you have the flow chart there.
I do.
It shows a book and deed for the middle section of this flow chart, but there's no dates on those. I think if we had dates on those.
Mr. Chair, can you hold on just 1 second?
Oh, sorry.
Can you just tell me what's different on the two? Just so I know.
Yeah, so I didn't have the date here, so I added the dates here. It's different, it's the wrong date, so I changed the dates. Then I added a date here. This here, no dates. So I just added dates pretty much so it'd be more clear to understand. The names and book pages and all that are the same.
Okay, so I don't know which document is correct. So we both have 2 very different documents here. So the document I have has, you gave them your version? Okay, so the version that we got in the code enforcement office, the planning office, and the assessor's office has Bruce Brady, Joyce Al-Darraji, and Adnan as their divided parcels of land for 9/11/2013. In the middle, we don't have any dates given. Do we have the copies of those? There's a whole bunch of them. Right here.
Yeah, that would be great.
Mr. Chairman, can I ask, I'm not sure which one I'm working off. Can I have the version that was just presented to the board?
So this is the old
Mr.
one you have,
Al-Darraji,
Jen?
do you by chance have an extra copy of
Is
the
the old
flow
one?
chart you presented? Is this the old one? Is this the
Still
old
not
Yes,
dates on-
but not the
says
one
no.
that was presented.
I don't think you have this one then.
Do you need another copy of that? Thank you so much. Appreciate it.
Our versions of this are very different. We never received the updated version.
So what is this you just gave us?
That's,
Me?
This is-
no,
That's the flow chart that Mr. Al-Darraji presented to us in the code office. This is the document that he submitted to us.
Oh.
This is the document that he submitted to you.
Oh, okay.
It's updated with dates.
Please see the top dates are very different.
Yeah.
So,
For the.
The three
first
lots.
Our
one,
document
divided
has
into
2013, his has 2007.
I changed the dates to be reflected more accurately.
Oh, I see,
Hmm. So 6 years later.
no, this still within the time frame as long as. So, looking at your chart,
Mine or Mr. Al-Darraji's?
yours, the one
Mine.
that you presented.
Okay, yep.
It looks essentially, we're at, when we come off Lot A, and we're at created Lot A, was that recorded? It shows it was recorded. What date was that Lot A recorded?
So we have no information on that in the town assessor's office. We never received those recorded deeds.
Okay.
And
I
those-
thought we were supposed to receive recorded deeds.
If they're recorded, we do receive them.
If they're not recorded,
We do not.
So we think that those don't exist?
well,
I'm just telling you how the assessing department works. They get it directly from the registry of deeds,
Yeah.
and they record every single deed in our system and update it.
and
So-
that's when, how the tax maps gets updated, when they get a deed that comes in,
That is correct.
that's how we adjust
how
our
we-
tax map.
Yeah, we send all that information to our mapper, and he updates it for us. That's how it works.
Okay,
So,
so,
I guess, Jen, I think we're all set for a second here.
Thank you.
Um,
I would like to.
Yeah, no, oh, come on back up.
To me,
What are you looking at? Which one?
I'm looking at the one you just gave us.
So the 2013 one?
I don't know.
Okay,
This one, the ones that are labeled lot A, B, C, D.
okay, yep.
Okay. It looks like two of those lots were merged to form, some of these things. Yeah, Bruce Brady and Joyce merged their pieces in order to create the lots A, B, and C.
Okay.
Is that the way I see it? It says portion merged.
This is not my flow chart, I'm not sure. It's
Oh.
Mr. Al-Darraji's. I
Oh,
didn't
okay.
create this.
All right. Sorry.
no, top, it says merged, because up here. It's convoluted.
Right,
Would you like me to answer that question?
come on up. Yes, that's fine.
So, you see Bruce is the back lot behind, if you look at the diagram here, you see that Bruce's lot was the back lot of this lot that got split right here. And so, it was learned later that the 10,000 square foot lots that Tom Harmon did along the shoreline was not right. It had to be a 40,000 square foot lot. So all we did was just, we incorporated some of the land here to add to Mr. Bruce's plot. So it'd become 40,000 square feet.
Okay, so you were treating these lots as contiguous pieces of land that could be taken from one and moved over to the other, and
We're family members. We can.
whatever they, yeah.
We're family members, and we decided that we would, if she needed some extra land, of course, it makes sense to give it to it, because otherwise it would be a useless lot.
I understand. However, by shuffling these around, you actually created a sold lot, Lot A, Lot B, Lot C, Lot D, and another sold lot. So you've created 1, 2, 3, 4, 5, 6 lots.
I have not created 6 lots. The 3 of us created 1 lot apiece.
See,
How come the names on the top 3 are different on each of these?
Because I made an error when I said that Bruce was the original purchaser from Pellegrino when it was my mother. So I was an error. Corrected. It was Bruce, and then you can see I moved Bruce down because I learned that Bruce was actually the second owner, so I moved his name down to the bottom square, the second square.
Okay, so this one is not correct.
No, that's
Correct.
no, that one's old. I found some errors as I was looking at it. I realized the dates were wrong, and so I wanted to make sure it was as accurate as possible when I came here, so I revised it. And this is all verifiable. I'm not sure.
I guess I'm still wondering, Mr. Chairman,
yes,
we have a total of, out of these 3 lots that are wiggled and waggled together and changed around because they're family, so they're, to me, they're considered 1 lot.
Only 1 lot happened that way.
What?
Only Bruce's lot happened that way. All the other lots were separate. If you look at the plans right now, you'll see that in the plan, it's dashed. There's a dashed line that shows the original 3 lots. This would be the original 1 lot here. The other dashed line is right here. You can see that was the second. And then the third is the bigger piece down here. So those dashed lines actually show you where the original lot, so you can see most of everything is within its own self, except we had to do that change to Bruce's again because the 10,000 square foot changed to 40,000 square foot. Otherwise, we wouldn't have had to do that. And it was just a fix, if you will. But it wasn't like we were moving things around and shuffling things all around and changing things back and forth.
this board has to figure out when these divisions happened and if we've done it in accordance with the regulations. And when I've got book and page numbers with no dates on there to tell me when that happened, and I'm not entirely sure that you can split a lot to the same person and call that a legal split. I mean, by definition, I own a piece of property on Carolyn Drive, and over the course of time, we've added pieces to it. It's considered a contiguous lot now. I don't get taxed on all the separate parcels and pieces. I get the tax on the whole piece.
Yeah.
So I'm really at a loss as to how I'm supposed to determine. Now, I'll go right number 2. You split a lot, there's no dates on when you split that lot, and
No, I said I did not split number 2. Remember, I said we kept it within ourselves, that I was going to build my home on that. So I'm not contending that that lot has been split. I'm not saying that lot has split. I even said to you that we did not. We kept it within our own name because I'm putting my house on that lot.
it doesn't matter which of these flow charts I look at, if I go number 2 straight down, it's split either to Joyce Al Jazari twice, or it's split to A and A Al Jazari twice.
Yeah.
the same parcel of land, the same owners.
I'm not saying I split that. I'm not trying to appeal to say that I split those two up. That's not what the appeal is here for. I already agreed with you that that has not been split up, and therefore it is one piece of land right there. That's not the argument. That's fine. You can leave it as one lot right there. That's fine. My argument is that I'm being told that something I was asked to do is the violation, and what I'm being held for here today, is that, and that I'm required now to go back to the drawing board and start all over again after 15 years of owning this property.
Just one second. I understand where your concern is, but I think the question gets back to, if there was no record of these lots anywhere,
They're all in New York Registry of Deeds. Every one
you
of
don't
them.
have any dates on there. You don't have any dates on these
The
to
date does
tell
not
me
mean it
when.
doesn't exist. It's because I didn't write a
But
date on
sir,
it.
it makes no difference whether it exists or not. In front of this board, it doesn't exist because there's no date on there. I can't, I'm supposed to determine when things got broken up. And if I can't, you can't tell me when these things got divided up, how am I supposed to make a determination if you did it, if they're in accordance with
Well,
state
then,
law?
then
or
give me a
this-
recess of 10 minutes then. I'll come back with the 4 dates for you. I gotta go to the bathroom anyway. How about that? Does that work for you?
You can do what you need to do.
Well, I mean, I can look up, it takes 2 minutes. It takes no time at all to get those dates. I can do it right now.
I'll let Jen, she had a comment anyway.
Maybe you can ask Mr. Al-Darraji how Douglas Bruce Brady comes into all these deeds. Because he is not listed on the flow chart at all.
On the one he gave you guys. Brady, he's on ours.
He's not on mine.
But, yeah, okay, right.
Yeah,
Yep.
no.
Well, where's yours, John?
It's that second one that was
This
given
one.
to you, remember?
Brady sell all of them.
Yeah, no. So he leaves out on the registry of deeds.
Mr. Chairman,
Can I
it's
talk or no?
I think it's important that we
Yeah.
let the applicant
Okay.
hear what you have to say.
Yeah, I
so we
think
can
you're right.
respond if necessary.
I don't think these were ever recorded separately, because if you look,
They're the same number,
exactly, where all these have different numbers.
right?
Except these
Well, he's
two.
saying that's, I guess that's just one lot now. So,
Well, it's different now.
Excuse me, Mr. Chair,
yes,
you need to refrain.
okay.
Is everyone cool enough in here? No. Well, they're having a little trouble hearing, so I was gonna turn on the AC.
I think we're
comfortable.
fine.
No? Okay.
At this time,
Can I say one other thing?
yes,
Can I finish? No?
well, just to, let's, I'll let you say one thing, then I'll let Jen say something.
Well, just before I look up the dates, I just want to say that, I'm here to prove that I never split a lot up more than twice to go to the planning board. I only proven here that I've only split it once. The date or no date, that proves that. I never split anything 3 times. Those deeds, even though there's no date on it, are legal.
I understand what you're telling me. Jen, did you have something that you wanted to say?
Yeah. So if you pull up some of these deeds on the Register of Deeds, York County deeds, and you can do it, where it is conveyed to Bruce Brady in that, number one, Bruce Brady, book 16412, page 184. It's actually not just conveyed to Bruce Brady, Douglas Bruce Brady. It's actually conveyed, I'm sorry.
I just couldn't hear it.
Okay, so if you pull up the deed listed under number one, his flow chart, book 16412, page 184, it's not conveyed to Bruce Brady. It's actually conveyed to Adnan, Al-Darraji, and Bruce Brady. So there's missing information on this flow chart that would be relevant to some of these splits, I think.
Okay, thanks.
Thank you. I'm just gonna step outside. I just need some air. So you can continue. I'm just gonna stand right over here for a minute.
I think if the town attorney would like to speak and help give us a little direction here, it may help, because I think I'm kind of struggling right now.
Sure. Of course, any factual determination is entirely up to this board. But what I can do is set the stage for the legal considerations that you need to be thinking about. So we already went through, and I'm not going to redefine, what a definition of subdivision is, what a tract or parcel is. What I have heard said by Mr. Al-Darraji, and also Jen McCabe had addressed this really important issue, and I haven't heard this board talk about it and ask questions about it, and I don't want it to be lost because I think it is really important, is that initial division from the Pellegrinos to Mr. Al-Darraji and various family members. So that's those lots 1, 2, and 3 in 2007. I absolutely understand and even sympathize with what Mr. Al-Darraji is saying, is that, hey, I didn't do that, that's not my fault, I just inherited it. But under Maine law, it's fairly clear that as a purchaser, or not just purchaser, anybody who becomes a predecessor in title, or successor in title, I should say, inherits the sins of the past.
Yep.
That's not a legal term, but it's just trying to make you understand that just because they weren't responsible for the problem does not mean they don't inherit it. And so I think it's really important to understand and do the analysis whether that first division in 2007 into those 3 separate lots constituted a subdivision that should have been reviewed by the planning board. If you find that, then I think it's also important to understand that all of those subsequent conveyances and divisions were tainted by that. And this board is not here to solve that problem. This board is not here to say, I often, not only is this my day and night job, I sit on a board of appeals in my own town, so I understand the job. It's hard, right? You're not here to solve that problem. I understand that there are folks out there who have purchased these lots that are not family members, and one might think, oh shoot, what happens to them? Not your problem, okay? But I do think you need to analyze the legal significance of that first out conveyance by the Pellegrinos of those 3 lots. And that is the first point of analysis. And then I think the second point, and then we have, again, I'm looking at either of these flow charts, regardless, right? You've got the first line, and then kind of the filling of the sandwich, so to speak, what happened in between, and then the fact that now you have 4 lots that are essentially in common ownership and what the implications are there. From a legal perspective, I think it's important, as I say, what is the implication of that first division, and then second, now that they are all in common ownership, you have to analyze, is that a tract or parcel? Look at that definition and determine, if they want to convey those portions out, if they can do that, or if they are required to get subdivision approval. So those, to me, that's the legal analysis that needs to be done. I know it's confusing, so if I can clarify that in any way, please ask questions that you may have.
Mr. Chairman, I just
Yes.
have a question. I heard what you said. My understanding that this board is to determine whether or not the appellant has made a case for a mistake.
Correct.
And so, to me, I just need the simple question is, has there been enough evidence submitted to me as to whether or not there was an administrative mistake by an officer of the town.
Mhm. And I absolutely agree with you. Your job is twofold, right? Because I'm assuming, and you know what they say about assuming, I shouldn't do that. But I am asking whether the board would like me to draft the findings in this matter. I've been taking notes, copious ones, so that I can do that if you would like me to do so. But to your point, there are two parts to any decision these board makes, right? Findings of fact, evidence, conclusions of law. And so in the end, your decision is to dovetail the important pieces is that you take the evidence, you put it within the legal framework, and that is how you decide whether or not to grant or deny the appeal based on whether the code enforcement officer has erred, right? So it is that kind of, what are the facts? What is the legal requirement? How do they go together? And so, yes, you're quite right that the evidence is really important, but we also have to understand what the legal issues are and knit them together.
I'm going to ask one more clarifying question. In 2007, when the lots were split, what was done wrong for that? When that split was done, why did it become a subdivision,
Sure,
I guess?
okay.
Is that the right question I want?
Yeah, and if you're asking me, again, that's your analysis, but I can tell you what my thoughts are around that regarding, and just opining on what the legal definition is.
Right.
Okay? So I don't have those deeds. I haven't looked at those deeds, okay? But let's assume that there was one, I'll call it the mother parcel, one mother single parcel.
Pellegrino's lot.
That Pellegrinos had. That's what they had. And then they out-conveyed those 3 lots to 3 separate individuals. When I say separate individuals, meaning they were not in common ownership. You've got Mr. Al-Darraji, you've got Joyce, I believe, and then you have both. So that is not common ownership. Those are 3 separate and distinctly owned parcels. Because, again, going back to the definition of what a subdivision is, that first division, that's okay.
Yep.
You can do that.
The second one was.
The second one is what triggered, if you're asking me if I'm looking at that law, that could be said to have triggered the definition of subdivision. The next piece of analysis, okay, so great, you've got a subdivision, who cares? Why is that relevant?
Wasn't approved.
Well, because the subdivision law under 4406 and your own subdivision regs say once you have a subdivision, then that must be essentially reviewed and blessed by a planning board. And in that process, the reason you do that is to make sure that, you know, the criteria under subdivision, we don't need to go into that, but more like, okay, are the roads big enough? Is there enough frontage? Is the soil erosion okay? Is there subsurface? Is that appropriate? So that's why, right? But the answer to the question of, and it's your analysis to do, you need to figure out and weigh in on whether that initial conveyance in 2007 was a subdivision. If so, then it's not a tough question. If it was, then it should have been reviewed by the planning board. And that is the question.
There's one other piece that comes up in this, and I'm having a little bit of a struggle with it, but I think I'm understanding, but I want to clarify. You can, if you own the property and you stay in the property, you can actually break it into 3 parcels, and it's not required to be a subdivision. Is that true?
So that, yes, but, and as we talked about before, I said there's a laundry list, quite a few exceptions to that definition.
That one's not
One of
here.
which is that, I think what you're referring to is a homestead exemption, meaning I'm staying there. I stay there. I'm not sure what the evidence is on that. It hasn't been before you. But let's just say hypothetically that Pellegrino said, you know what, I'm going to divide this. I'm going to stay on this lot for 5 years, 10 years, whatever that requirement is. That's an exception, right? If another one, again, this is just to get, I'm not saying this happened. I'm just giving you
This
examples.
case.
If
Right, examples.
there was a divorce and by court order, you know, the parties wanted to divide that up and the court would say, you know what, In the divorce, that often happens in a divorce decree. They separate, not that anybody, exes necessarily want to live next to each other, but they might divide that property. And the court
Another
would say,
exemption.
hey, that's not a, or if I die and my estate is conveying it, or if I'm conveying it to family members, you know. But I don't think the evidence is in that any of those exceptions apply here. Maybe it does, but I didn't hear evidence to suggest that it does.
Quick question.
Yes.
When you explained that if the subdivision is, the rules are such that it should have triggered a review by the planning board, okay? Would that correlate with the letter that said something to the effect of, that it was, the evidence was, or the testimony was, that that it had to start all over again? Is there a connection there?
Yeah, I don't know if it said, I don't know actually, let me look at the letter. I'm not sure it said you have to start all over again. I think that was Mr. Al-Darraji's interpretation. But what I am saying is that this, if you find that original 2007 lot split required subdivision approval, you can't cure the original sin, so to
Right.
speak,
Yeah, this is-
by subsequent conveyances. And
This is a tree with no trunk.
correct.
When you put it
Yes,
upside
and
down.
what I think that, assuming that either of these two flowcharts are correct, that I think the evidence does suggest that Mr. Darraji or his family members did not subsequently subdivide these parcels. But that is not necessarily the issue. The issue is what happened, what he inherited.
Right.
And I know that, I'm looking at that, the appeal, the administrative appeal, and number one, the first statement is, we are not responsible for the Pellegrino division into 3 lots.
And that is true. You aren't responsible.
They are not
Right.
responsible for
Separate.
the division.
Right.
True, but they are responsible for the implications of that under Maine law.
They are responsible for what?
The implications
Yeah,
of
okay.
that, meaning that,
Problem.
for example, and I'm just using a totally separate example. Say I purchased a lot from somebody, and it's sitting on, and the shed there doesn't meet setbacks. Just because I didn't plunk that shed in the wrong place doesn't mean that the code enforcement officer can't say, hey, new owner of property, there's a violation on your property. So violations run with the land. They do not run with the owner, if that makes sense.
It's still broken when you sell it to the next person.
What?
It's still broken when you sell it to the next person. Mr. Al-Darraji, would you like to speak to the first split?
Well, I mean, I think it was said, if, it's a big word here, if the Pellegrinos did it incorrectly, how are we to know? How are we to know, and whose responsibility is to find that out? And if you do find out it was done wrong, what is the repercussions? Who has to do what at that point?
Well, in your flow chart, clearly you've got 3 separate names on 3 parcels of
Yes.
land
Yes?
that came from
Yeah, but
the
you had said it
Pellegrinos. So
yourself, sir.
there was a division right there that happened.
Yeah, you guys stated yourself, sir, that within that homestead law, if you stay within the place for 5 years, Mr. Pellegrino owned that place for 30 years. So I'm sure that civil consultants must have looked at all the criteria before doing so. Again, not my bag. That's not my responsibility. I don't know what the criteria was that they looked at, but being that he's pretty well-known engineer in Maine,
Well-
it'd be a pretty major mistake.
Don't know if you can speak for
Well,
civil
That's my
consultants.
opinion. That's just my opinion. I feel they're a good
I just-
engineering group, so.
In the records, we show that Pellegrinos owned one parcel of land.
Mhm.
And now we have 3 parcels of land that were split up.
Mhm.
We need to know, the town says, we need to know how those lots were split up. I mean, was it done appropriately? I mean, you were the one that bought the pieces of land.
That's right, I bought them in good faith.
But you need,
Good faith or due diligence when you purchase something else too.
So, Ms. Bowman, you can go back into the records, and there was no ever planning board approval for this initial split from Pellegrino
we'll
to,
let Jen,
right?
you want to,
There's no record of it, right? Or is there?
This lot split never received subdivision review, ever.
Okay, so it was seemingly illegally sold in 3 different lots.
That's correct.
Okay.
Has Mr. Al Jazari ever gone to the planning board?
No. And he was told to by James, who was our town planner at the time.
I have been in front of the planning board, I went all the way.
You wanna step up?
Not for the original 3 lot split.
Well, that was all part of it. This is, the whole start of this was to do a subdivision through the planning board, which we tried diligently to do. And we got through all the way through the preliminary stage with just a final stage left. And we were all approved by the planning board. And the reason why I didn't get to the final is because 2 reasons. One, it was 2008, and so that hit hard with the economic disaster. And 2, the Berwick Sewer District could not come up with a way that they wanted to bring the sewer up. They were having a hard time, should it be a pump, should we be allowed to do single pump, or should it be one big main station in the center of the cul-de-sac? And so they could not come up with an answer, and I believe civil consultants and the planning board, we all met together to try to figure out how that would be, and that never happened. So it got tabled because of the economy at the same time. And so it was tabled all the way till 2021, where I then came back to Jay Wheeler at the Berwick Sewer District and asked him if what the system was, and at that time he still didn't know. And so I believe that he went in front of the board and came up with a solution for the sewer district that they would be happy with, and how to get the sewer up into the street. So that's what I know about that.
I'm not going to speak for Jay Wheeler here. I'm going to speak on behalf of the town. And subdivision approval comes in front of the planning board several times a year. And it's never been an issue before to figure out how to get sewer down to a road that should be on town sewer.
Mr. Chairman, can I just ask a clarifying question?
Yes.
And it's for both parties. I understand that Mr. Al-Darraji said, well, we were trying to figure out how to get town sewer up, or town water up to those parcels. But, and again, this is my ignorance of the town, but isn't the case that not the whole town is on town water and sewer? So in those cases, isn't it possible that any development could do a subsurface septic system as long as it met with the plumbing code and the subsurface rules?
I'll speak to that. That's a matter of lot size. So for different districts here in the town of Berwick, depending if you live on the R1, R2, or R3 zone, to be on town sewer water in the R1 district, which is our road, Merriam Street, you only need 10,000 square feet per lot. To be on septics, I believe, I don't have it in front of me, it's rare that it's septics, but do you have your land use ordinance? Can I just see that real quick? I'm pretty sure it's double. I just want to make sure that I say it clearly here. Additional requirements.
While you're looking for that, but
I have it.
is it the case though that I understand that the minimum lot size is substantially different, but just because there isn't sewer or public sewer and water doesn't mean you can't build, you just have to install a septic system.
Yeah, I'd be interested to have Mr. Al-Darraji show a couple of different plans that might have come through at that time, and to see if he wanted to upgrade his subdivision to more lots. I don't have anything in writing, but I do believe when he first approached James and I, and he can speak better to it, maybe not, but I'm almost positive that he came with less lots, and he wanted us to help him add lots. And we were happy to do so if he had the proper dimensional requirement to do so. To go on public sewer and water in the R1 zone, it's 10,000 square feet per lot. To go on septic system in the R1 zone, it is 20,000 square feet per lot that's needed.
So essentially, if sewer and water wasn't available, if you wanted to make a buildable lot in that area, you'd have to double the lot size
Correct.
to be able to accept the septic and the
Yeah.
well. Okay. Did that help?
Yeah, and I didn't mean to go off on
No.
a tangent. I just wanted to understand that.
Okay, I guess I can ask you this, Jen. So, maybe I should ask Mr. Al Jazari. These,
Do you want to just ask us both? Wanna come up?
we have these 4 lots now, 4 contiguous lots, same owner, okay, in these lots. Are you now, and this is as of 2021, that these became,
Deeded.
They were registered at the Registry of Deeds in 2021.
Okay, so
Yep.
this is the first time that this parcel of land now has 4 lots with the same name. So it's a contiguous lot now. Whereas before, when it was the 3 of you, it was 3 separate people. Now it's one contiguous piece of land. And you're trying now, and if that's true, then according to the subdivision regulations, if you have this contiguous lot, then if you want to divide any of that land up now, you have to, it's a subdivision if you do 3 lots in a 5-year period. Is that correct?
Yes.
Right, but if they all came from 3 different individuals, then they're not over 3 lots. It's 1 lot, 2 lots, which we haven't even divided yet, and then the 3rd one. So they're coming from 3 different ownerships, so therefore, they're not all the same.
Are you,
Makes sense?
I'm a little confused, like,
Pat, I think the best is maybe to rely on the attorney to kind of explain it for you
okay.
a little bit better.
One of the things I'm puzzled about now is,
You might not want
are you interested, if he wants to subdivide this land now, then, he has a starting date of 2021 when these 4 people own this together. And so, is that what it means when you say the clock is starting to tick again?
I'm not sure who's your question to?
I have no
Who are you asking?
Yes, I was
should be
told
directing
that.
it to you.
Why don't we ask?
I would ask the attorney, yeah.
So I think what I'm going to try to do out of an absolute abundance of fairness, because I think it's really important to give everybody their due, right, is I'm going to try to distill down what each side's argument is, and then talk about what the law is, okay? When I have, and again, I'm sure the parties will correct me and jump up after I'm done to take exception to what how I've characterized their arguments, okay? So my first task is to characterize each side, and then after that, to talk about what I think the law says, okay? Is that a fair way to approach this?
Mhm.
Okay. So what I believe Mr. Al-Darraji's position is that because that original 3-lot division from Pellegrino, he had nothing to do with that, that wasn't his fault, had the Pellegrinos, should they have gone to the planning board? Maybe they should have, but he didn't do it, so therefore it's not his fault. I think as I explained to you, I believe that is a legally incorrect position, okay? I think what he is saying is, so that's the first thing that happened. Then we get down to the bottom of the chart where you've got, I think what you were referencing was the 4 lots that are now in common ownership, right? And so under the definition of tractor parcel and subdivision, if they are all in that common ownership, then they do have to, that basically would set the clock back, as Mr. Al-Darraji says, is that now that it's swept back into common ownership, in order to convey any of those parcels out, or I should say 3, right? If he was going to,
Right.
not 4, but 3, then that would trigger subdivision review. But based on this plan that we have and the flow chart where we see 4 in common ownership, that, in my view, meets the definition of subdivision, okay? I think what his position is that it doesn't matter because these were all separate lots beforehand and they haven't changed, and maybe I'm wrong. What he is saying is the 4 at the bottom have not changed configuration from the lines above them. Is that correct?
Correct.
Okay, so what he is, so let me just broaden the lens here for a second. Leave this aside and I'll give you a hypothetical example, okay? Say that these 4, say there are 4 lots that in 2000, an applicant comes to the planning board and gets subdivision approval for 4-lot subdivision, okay? They do that. And then, after getting that approval, they convey out to the same person. So I, Leah Rachin, buy 4 lots, not Leah Rachin and Owen, my son, just Leah Rachin. I buy 4 lots that are contiguous and they're right next to each other. That is not a tractor parcel anymore in common ownership because they've already received planning board approval as separate lots. Okay, that's the critical factor. I think it's important to understand. Once a planning board has blessed those lots and say this plan was actually approved by the planning board, then once those are approved, that's a subdivision, and one person can buy every single darn lot in that subdivision, and that doesn't make it back to one tractor parcel. Because once it's been approved, each one of those things are a lot of record, and they're
Named
blessed and they're
individually.
legal, okay? The issue here is, as I interpret it, is that that original division of 3 lots was not blessed, was not reviewed, was not approved. And so therefore, all the subsequent conveyances were tainted. And they were not separate lots of record, right? They weren't blessed. I mean, I shouldn't say that. They were lots of record in the fact that they were recorded in the registry, but they constituted illegal lots because they were not granted subdivision approval. So you get, now I'm back to my plan. Now that, because you get down here, had these 4 lots been approved and they were now in common ownership, it wouldn't matter, that would be okay. But because, as I say, jokingly but not really, original sin, anything that happened subsequently was not legal. And I'm not saying that's fair or right, and it's unfortunate, but it is my belief that under Maine law, whoever takes those subsequent conveyances is subject to the problem. Inherits the problem, so to speak.
Kind of think this is like our, remember the appeal that was signed by wrong person filling in, and it was all argumentating. It's kind of where we're at here is that this initial one wasn't legitimate, therefore everything after it's not legitimate. So she can't approve any divisions or doing anything with anything down here. Nothing can be approved past the very top. She can't approve any of it because none of it's legitimate.
All the town is seeking is
So-
for Mr. Al-Darraji to come and get blessed by the planning board for his lots and move on with the subdivision.
Right? So, I feel for you, I understand, right, you got,
Yeah, just not be discussing it with him per se, I think.
I feel for the appealee, for what happened. Getting this illegitimate three lots, but you're stuck with it now, kind of, you know, is the way to put it. You're stuck with it now, and you have to deal with what you have now. It sounds like you have to backpedal a ways and go from there.
Mr. Chairman,
Yes,
I just would like to, whoever would want to answer the question, or speak to it, I should say, is I'm still at the point where I'm saying, my job here is to deal with the appellant's claim. And the appellant is saying a mistake was made, an administrative error was made, and therefore we should, act accordingly. But I haven't seen currently I haven't seen the evidence that a mistake was made, so I would appreciate some input that hasn't already been made that would indicate whether or not a mistake was made or not. In addition, and it's sort of a corollary to this, is that original letter that the appellant wrote with 11 points on it, there were some serious accusations. They were talking about being discriminated against, etc. There was a lot on that 11-point letter. And that bothers me because we don't have any jurisdiction on any of those kinds of accusations, because to me, that would be some kind of a law of court, the Superior Court or some court that would not be the planning board. But that kind of evidence that was presented to us still weighs in my head, so I'm wondering, and I haven't heard any other evidence that the code enforcement officer made a mistake in that letter. But the background of all of these accusations, it weighs in my mind.
Mr. Chairman, I can address, if you'd like me to, just the situation with the discrimination and the bias and those allegations, if you want me to talk about what, if any, role this board has in hearing, well, you've heard it, but weighing in on that. I'm happy to discuss that. If not, I'm happy to be quiet.
I hesitate to even get into that, but at the same time, I think we're a young board and we're trying to learn, so I think it probably would be beneficial.
Okay. So here's what I would say to that, and it kind of gets back to the appellate versus de novo standard of review. And I know, like, I'm throwing out Latin words, but they're actually important for this particular reason, okay? So if it was appellate, you're just looking at the record that was in front of the decision maker, here, the code officer, right? If it were just appellate review, I think the state of mind and bias and alleged bias would be really important, okay? And not that those allegations aren't important. I'm not minimizing them in any way, right? Of course, everybody should have a fair shot at having a decision that's unbiased. You've heard testimony from the code enforcement officer in that regard, responding to that. But frankly, because as we talked about, your role is de novo, meaning fresh, tabula rasa, from the beginning. You're not giving, and not that I'm saying she's not entitled to it, but you're not giving any deference to the code officer's decision because your ordinance tells you not to do so, right? You are taking new evidence. If you look at the procedure, it's clear you're taking new evidence, you're hearing oral testimony, cross-examination is allowed. So your role is to look at this from scratch. And so even if, and I'm not saying this is the case, but let's assume that the code officer or some decision maker was extremely biased, it doesn't necessarily matter because you're looking at this from scratch, right? So what would be actually problematic if somebody was alleging that any board member had bias, right? That is because you essentially are sitting as the judge and jury, and that, as the decision maker, it's important that you be fair and unbiased.
Right.
But I've not heard any allegations that you are not. And so because it's a de novo review, I think those allegations of bias are, and again, I'm not minimizing them or saying that those kind of allegations are unimportant, but you're the decision maker now, okay? So it's your bias and your open-mindedness that's critical here.
Thank you. Does anyone have any more to say as far as for the public opportunity to speak? We have in the past, and I believe we'll continue to do that, if during our discussions there's a question that comes up, we will ask people to come up and address any questions that we might have. But I think we're actually been kind of in the middle of discussing now, and I'm not sure that was what we should have been doing, but I mean, we're a volunteer board. We're trying to do the best we can to understand the situation and come to a fair decision. So that's why, you know, I've kind of allowed probably more than what should have happened. But if feel like you're all set, we'll close the public hearing comment part and go into the discussion phase for the board. You're all set, Ms. McCabe?
It's here somewhere. I think it's underneath.
So, I just want to bring up the fact that, you know, the bias and the discrimination and harassment, it may not be your responsibility in that respect, and it might not be on you, but it does take a toll on the individual. And I gotta imagine that if you hear something, bias or not, you're gonna want to favor the employee that you've hired here. If it's coming from her, you're gonna want to back her up. She's your employee. She's here to set the rules, and so it's gonna be hard for me to convince you otherwise. I have emails, I have documentation very thick that shows I've sent many emails out with no responses, that I tried to find out what could be done if we could sit down and have a discussion and meet with no responses. And then one time we do meet and I have a direction to go do something, lo and behold, it sets me back 15 years. And so if you can't see the big picture here, then I can't, so there's nothing else I can say. But it's pretty clear and obvious that I've been railroaded here for a better lack of a better word. And again, if you can't see that, the big picture, then I can't explain that to you.
If the board would like, I'd be happy to speak to those bias, because they're just simply not true.
I believe that we're here, for me, to make sure that the subdivision is necessary, your decision is appropriate. We're working our way through the splits, and I think that's what our job is here, is to make sure that everything was followed in accordance with the law that we're given to decide. So I think at this point in time, we're gonna, if we have any other questions from, just one second. I think unless there's some more evidence, as Ernie would say, to the subdivision that we're trying to determine whether it should have been or not should have been a subdivision, in accordance with the code of officers letter, if there's any more evidence, we're willing to listen. But if there's no more clarifications on that, I think I'm ready to close.
I think on behalf of the town, we're all set. Thank you.
Okay. So, we've heard from Mr. Al Jazari and Ms. McCabe and the lawyer. We've got this in front of us now. I would guess, I heard Mr. Cotton talk about the split. What is the original split? What is, do we need any more information to determine if it was? Do any of you need any more information on your own minds to understand whether it was a split that should have been gone to subdivision or not? Is there anything else that's gonna help you better understand that?
Are you asking if we agree?
No, I'm just saying,
Understand.
I'm not,
We understand.
do you need more information to understand
No.
what was said and what your feelings are on that particular part of the argument? Yes, Ernie?
My answer to that question is, I probably don't have any more evidence in terms of, but there is that one piece that the attorney mentioned, and I know that we have the authority to look at things afresh. And the question is, do we want to look at any more information or interview anybody else? Or fact find on our own, which is fresh.
Let me address that. I don't want to have misspoken, okay? When I say you look at it afresh, you are looking at what the parties are presenting to you. You do not fact find. You're basing your decision on what is presented to you by the parties. They have the burden of proof. This board does not go on its own separate fact-finding missions, okay?
Okay.
Just to be clear, and if I misspoke, I do apologize in that.
So a site review would not be, I realize that this is not, but site reviews, if appellate comes to us with something else.
I would need to look at your powers. I mean, there may be something, I think just as a matter of course, a lot of ordinances say, hey, if you need to do a site review, you can order that. But in this case, I would say that looking at the face of, like, the lay of the land or what's happening on the face of the earth really isn't what's at issue here. It's whether or not a subdivision was created.
Okay.
So again, I am not dissuading you from that if you feel like a site plan visit or a site visit is important, but in this case, I'm not sure it's particularly relevant to the issues.
Right. I agree.
When,
That answers my question.
you all set? As far as the flow chart and the dates, we need any more clarification on where that's going?
I do not.
So, have we heard all the information we needed? Are we prepared to offer a finding? Is that, I guess, where I'm headed with this? You've heard the information, you don't need any further information? We're all set? Okay, having said that, is there a motion on the table then? Someone want to make a motion?
I'd like to make a motion to deny the appeal on the basis that the original split was illegitimate and she can't approve things further down the line based on that.
So we have the motion on the table to deny the appeal
To deny the appeal.
based on the split, the three split, the lots were split in 2007. I should,
Based on this initial split that was not done properly by the prior owners of the property, everything after is not legitimate because of this. So she cannot approve something here when the start was bad. So it's the basis for the denial of the appeal.
And if I might just amend that motion if I can, and therefore we find that the code enforcement officer did not err in her May 3rd, 2022 letter, if that makes sense.
No, it absolutely does. So, and therefore, based on this fact here, we find that the code enforcement officer did not make a wrong judgment in denying the application.
I have a motion. Is there a second?
I'll second.
I have a second from Mr. Beach. Is there any further discussion on this issue at this time? We know that there's a motion and a second on the table. Is everyone prepared?
I just want to say that, for me, there's all these charts of who and what, when, and how. I'm sure they're relevant to a certain extent, but my focus is on, was there enough evidence to convince me that the code enforcement officer made an error, an administrative error? And to be honest with you, I did not hear enough evidence that tells me that an administrative error was made. Because to me, our job is either to, work with variances or administrative errors, or pass it on to the planning board for other considerations. Those are the only options that we have. We can't get into all of the nuances of these letters and charts and so forth, because to me, I want to get to the core of the appellant's appeal. What was the appeal? And he was appealing an administrative error, period. And I don't have that. I don't have the clarity of evidence.
We all set to vote? I'm going to ask for a show of hands for all those in favor of the appeal, or favor of the motion that was made.
And the
So-
motion is denying the appeal.
Right, we're going to raise our hands if we agree with the motion and the motion was to deny.
All right, do we have it on record as to what our motion is?
Yes,
I think you have a
Video, yes.
recording secretary,
Yes.
correct?
yes,
Yeah.
we do.
Okay.
All right, so a show of hands is will essentially deny the appeal.
And can I make a point of clarification? This is super lawyery, but I
No,
just
I
want to make sure
wanna make
that the record is clear. You had taken a vote earlier to deny the portion of the appeal relating to the septic.
Okay.
This is denying the appeal relating to the subdivision issue, which is clear.
Correct.
So
We can
you're
put them
you're
together.
going to vote on that. Then I think just to wrap it all up in a neat little bow at the end, I think you want to make a formal vote to whether just to grant or deny the appeal, ultimately. So
Okay.
you'll have two motions, and then we can talk about what's next and procedurally.
Okay.
Okay.
So I'm going to ask everyone at this point in time to vote. All in favor of the motion? Motion carries.
And so I think, just to wrap it up, I would say somebody should make a motion to deny the appeal. I'm assuming it's a denial based on your prior findings, and just say, move to deny the appeal based on our prior findings.
So moved.
I'd like to make a motion to deny the first trade of the appeal. And so, in a whole, both trades of the appeal are denied. I'd like to make a motion to vote on that.
Second?
Second.
All those in favor?
Pardon me?
So, adjourn now, or do you?
I think before you do that, what I'd like to do is talk about just some procedural things about findings, all
Okay.
right? What I will do is, so under the appeal provisions of the state statutes and under your own ordinances, is that the appellant has the right to appeal within 45 days of the vote, okay? Not the written decision. So they should govern themselves accordingly, because a lot of people believe that appeal period doesn't start running until you have a written decision, okay? So what I'm going to do is to circulate quickly as I can, in the next couple of days, a draft findings, which you will have to consider yourselves and take up and consider. And this is something that is a bit tricky, under the state statute, it talks about how quickly you have to turn around those decisions, right? And it says that you need to give a written decision. Do I have this in front of me? I believe it's 10 days from the actual vote. I could be wrong there. But what I think is important is, here we are, notice of decision must be mailed within 7 days of the board's decision, okay? So what is important is that you review these findings to make sure that they are consistent with, I'm gonna draft them.
Right.
My hope is that they are consistent with your findings and your deliberations, but it's important that you exercise your independent judgment and make sure that they're appropriate. So what I would suggest is that you meet within that 7-day period and authorize the chair to sign it. So that's my recommendation, but I will get these to you in the next couple of days. But just for the Mr. Al-Darraji's benefit, it's important to understand when the clock starts ticking in the event that he wants to bring an appeal.
Appeal the appeal.
Correct.
Basically.
And as part of any findings and conclusions that I will draft you, it will have the notice of appeal rights on it right there, so that will guide the applicant and what's next if in fact they decide to move forward.
So, assuming that this comes quite quickly, is there, the suggestions within the 7 days, what time do we want to meet? We should pick a time while we're here that's convenient, so that we're not trying to track people down.
I'm pretty well open.
Is,
Okay, thank you.
thank you. Tammy, is there a day that's better for you?
Monday right now, there's a meeting for Envision Berwick, so we could always meet upstairs and have it videoed. She can move a camera possibly upstairs at the town hall, or possibly Tuesday. Monday right now looks better than Tuesday.
Monday?
And that's
Or
just
the
a
date
notice, that should be just obviously a public meeting that's noticed.
Right.
Correct, yeah, we'll do an agenda and get it published the way we normally.
Great.
What's that date? What's the date? 7.
Monday's the 18th. The 7th day
We okay?
would be next Wednesday.
That's fine.
All right, so let's plan on meeting at 6:30 on Monday.
Or do you want 6 o'clock?
6 is good.
What?
I'm good with 6. She asked if we want 6.
You okay with 6?
6:30.
It's fine. Yeah,
6
good.
is fine?
I cannot meet, I cannot meet that
That early?
time. I can meet the day, but not the time.
6:30?
No, I can't meet it from 6 to 8 o'clock. I have another commitment.
We can. So Monday's off the table for
It's all
any.
right. I mean,
Well, no. You'll still have a quorum because there will be still 4
Right.
of you.
right.
If the other 4 can make it, you'll still have a quorum.
Okay. So 6 o'clock on Monday,
Yep, and we'll get that notice out.
the
tomorrow.
18th.
And just a procedural thing, usually I draft them that the chair will sign, but you will, at the end, you will vote to adopt the findings as amended, assuming that, you're making changes, and that you will, second part of that motion in to authorize the chair to sign on the board's behalf.
Tammy's writing it right down so that we get it exactly the way we need to.
So basically, you're making us minutes. Basically, it's minutes.
What's that?
It's minutes.
No, she's doing
So
the
she's gonna, be finding a
I'm
fact.
drafting the findings and conclusions.
We'll also have the minutes available Monday night too. Might as well do them both at that time.
Okay. So are we all set?
Thank you so much. You were wonderful.
Oh, my pleasure. Thank you for having me.
I guess, was I supposed to hit this to
Yeah.
start? We'll adjourn? Or do we need a motion to adjourn?
Yeah, I didn't see a
You
motion.
need a motion to adjourn.
Let's have a motion to
I'd like to make a
adjourn.
motion to adjourn.
Second, we got a,
Third.
all right, all
I
in
will say
favor?
in my career, I've never seen that one be anything but unanimous, that motion. Nice seeing some of your papers.
I don't.